Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to this course on Islamic inheritance law. In this session, we shall be looking at the conditions that are necessary for inheritance to take place. There are three conditions that must all be fulfilled before inheritance can be applied. The first condition is the death of the propositus, the person from whom the estate is to be inherited, known in Arabic as al-muwarith. His death must be reliably established, either by clear witness death or by a formal judicial ruling that he is to be presumed dead, as in the case of a long-term missing person, a topic we shall discuss later in this course. The second condition is that there must be a living heir, al-warith. In other words, a lawful heir must be alive at the time of the propositus's death, because only those who are alive then can inherit, and this principle also applies to legatees. If an heir later dies before the estate is actually distributed, his right does not vanish. His fixed share is preserved and then passed on to his own heirs. As for a child in the womb, it is entitled to inherit only if it is ultimately born alive, and a provisional share is reserved for it until the outcome of the pregnancy is known, details of which, insha'Allah, we will study later in the course. The third condition is that there must be a valid cause of inheritance. In other words, there has to be a recognized Sharia link between the deceased and the person who is to inherit, such as a blood relationship, nasab, a valid marriage contract, nikah, or, in certain historical cases, a bond of wala arising from emancipation. Where no such recognized cause exists, no right to inherit is established. This brings us to the end of this session. Insha'Allah, see you in the next one.